There are a lot of alimony myths floating around in Florida these days. So in this video, I'm going to explain how judges decide if there's going to be alimony, how much it's going to be, and how long it's going to last. I'm Vanessa Vasquez de Lara, founder of the Vasquez de Lara Law Group here in Miami, where we make lives better in and out of family court. Sometimes that means bold representation, but often it means simple, smart steps that lower conflict and give you control. When it comes to alimony, you want a plan that fits real life, not just paperwork. You want to know what to expect so you can budget with less trauma, more clarity, and a path that feels fair. So take a breath. Whether you think you'll receive alimony or whether you think you'll have to pay it, you just need a clear map. First, I'll show you what changed in Florida's alimony law, like the fact that permanent alimony is gone. Next, I'll explain the 4 types of alimony we still use: temporary, bridge the gap, rehabilitative, and durational. You'll hear what each one does, how long it can last, and when it fits. Then we'll cover amount and time, how judges decide how much support and for how long. You'll see the caps that limit awards and the factors that move the needle. And I'll give you 3 real-world scenarios in plain English. If you want, grab a notepad so you can write down the 2 big words we'll come back to over and over: need and ability. These 2 words are the center of every alimony decision. And a quick note before we dive in: this is general information for Florida, not legal advice for your specific case. Your facts matter, so for advice on your specific situation, talk to a Florida family law attorney like one on my team. Now we're going to talk about alimony at a glance, what changed and what always matters. So here's the big picture. After the alimony reform in 2023, permanent alimony is gone in Florida. Today, judges use a small set of tools that are time-limited and purpose-driven. It makes outcomes more predictable and plans easier to build. But every case still starts with 2 questions. Does one spouse have a real financial need? And does the other spouse have the ability to pay something towards that need? If the answer to both questions is yes, we pick the type of alimony that fits. If the answer to either is no, unfortunately, that means alimony is unlikely. But even though permanent alimony is gone, judges still look at the big picture to keep things fair. The standard of living during marriage, the length of the marriage, each person's income, assets, and earning capacity, contributions to the family and to each other's careers, age and health, childcare duties, taxes, and the economic impact of an affair if marital money was spent on it. Ultimately, the 2023 changes give us a clearer menu of alimony types, caps on the amount and time for durational alimony, and cleaner rules for modifying support when big life changes happen, like retirement. So let's walk through that menu. The 4 types of alimony in plain English. There are 4 basic types of alimony in Florida. Temporary alimony keeps life steady while the divorce is happening. It helps with rent, groceries, or insurance during the case. It ends when the judge signs the final judgment and the divorce is finalized. Bridge the gap alimony helps you land on your feet right after divorce. Think short, specific needs like rent, a car payment, and moving costs. It can last up to 2 years. Once the judge sets it, the amount and length do not change. Rehabilitative alimony helps you re-enter the workforce or finish a plan to be self-supporting. It could fund a certification, a degree, or a skill development program. But you do need a written plan that says what you're going to do and how long is it going to take. It can last up to 5 years. But if you finish early, it can end early. And if you don't follow through with the plan, the alimony can be changed or ended. Durational alimony is the type most people think of when they think about alimony. It's the longer-term alimony that fills the gap in one spouse's income when the other types don't fit. But it's time-limited and amount-limited by Florida law. It can also be changed if the paying spouse loses a job or retires, and stopped altogether if the receiving spouse gets remarried or enters into a supportive relationship. So now that you know the types, let's talk about the guidelines that set how much and how long durational alimony can last. First, the amount guidelines. For durational alimony, the monthly amount has a hard ceiling. It cannot be more than the recipient's reasonable need. There are several factors that go into reasonable need, but it largely has to do with your income and the standard of living you had in the marriage. So if the court decides you had a $6,000 a month lifestyle and you make $5,000 a month, don't expect more than $1,000 in alimony, but that's just one factor. It also can be more than 35% of the difference between your net income and the other side's net income. So if you bring home $5,000 a month and your spouse brings home $7,000, that difference is only $2,000, and 35% of that would only be $700. The judge must, that's a must, not a may, pick the lower of those two numbers. And that's just a ceiling, not a promise. The final number can be less if the facts call for it. Next, we have the time guideline. In other words, how long will one spouse have to pay? Durational alimony is time limited, meaning the length of the award is tied to the length of the marriage. If you were married for 3 years or less, you will not get any durational alimony at all. Short-term marriages between 3 and 10 years are capped at 50% of the marriage. So if you're married for 8 years, at most what you can get is 4 years of alimony. Moderate-term marriages are between 10 and 20 years. They're capped at 60% of the marriage. So a 15-year marriage would be capped at 9 years of alimony. Long-term marriages are ones that last for 20 years or more. They get the highest cap, 75%. So a 28-year marriage would be capped at 21 years of alimony. There are rare, exceptional cases where a judge can go longer, but think of these caps as really strong guardrails. The most important thing to understand here is that every case will be different. All of your specific details will matter a lot. So when you hear a number from a friend's case, don't assume that's even close to what you're going to get or what you're going to have to pay. Your need and ability factors are different. Your marriage length is probably different, and your result will generally fit your facts. So now that we've established what the guidelines are, let's look at the facts that steer the decision within those guidelines. What facts move the number up or down? Remember, the guidelines are generally setting the caps on alimony, but when it comes to need and ability, judges will look at some other factors as well. But one I can tell you that they don't look at is gender. While it is typically the husband who makes more money and pays alimony, that is definitely not a mandate. I can't tell you how many times I've had women be shocked at the fact that they were going to have to pay alimony. But sorry, ladies, equality is a double-edged sword. While some judges might have a bias towards men receiving alimony, the law is very clear. It is only about need and ability. Now, when it comes to need, one of the most debated factors is the standard of living during the marriage. Courts use this as a reference point, not as a guarantee. So you might not need weekly trips to the spa or golf course and a 2-week Mediterranean cruise, but the court is also not going to assume you can survive on ramen and government cheese either. Another factor is not just your current income, but your earning capacity. Let's say one spouse was a lawyer and decided to stay at home with the kids. So for the last few years, that person's income was zero. But the court is also going to look at what that person could be making if they went back to work, making a lawyer's salary. The court will also consider things like childcare responsibilities after the divorce. If one parent has more of the responsibilities, that could affect their work ability, which will increase their need. And judges are going to look at all the contributions to the marriage. Paychecks matter, but so does homemaking, raising children, and supporting a partner's career. If one spouse held the home together so the other could build a business, for example, that contribution is absolutely going to count. The income is going to be seen as belonging to the marriage, not just to the spouse whose name was on the check. And don't forget that what you own and what the other spouse owns after the division is also going to play a factor, especially if those assets are income generating, like a rental property. This could also include non-marital assets or an inheritance, because they could affect those two big factors, need and ability. And finally, one of the hardest factors for people to hear about is the impact of an affair. The judge is generally not going to punish one spouse for having an affair by making them pay more or receive less alimony. But what it can affect is need and ability to pay. If marital funds were spent on the affair, that can definitely affect the economics of alimony. If all this sounds a little complex, yeah, it is. Alimony is not as cut and dry as child support. So now let's put all of these factors into 3 real-world scenarios. First, Jessica and Mike. They are married 4 years with no kids, and they both work. Mike is keeping the house, so Jessica needs moving costs, first and last month's rent, and a few months of bills to get on her feet. This is likely a case for bridge-the-gap alimony, short and specific. So Jessica might get $1,800 a month for 12 months. and then it's done. Now, let's look at Amanda and Carlos. They were married for 9 years, and Amanda left her nursing career when their son was born. But if she finishes her schooling to become a nurse practitioner, she'll be making as much, if not more, than Carlos. This could be a case for rehabilitative alimony. Amanda would have a detailed plan with all of her required courses and exams. And in this situation, Amanda might get $2,200 a month for 3 years as long as she's working through her plan. And last but not least, Patricia and Robert. They were married for 18 years. Patricia managed the household and supported Robert's accounting practice. So now she's 52 with some health issues. Robert's net income was $15,000 a month, while Patricia brought home $3,000 a month from a part-time business. Their net income difference is $12,000 a month. 35% of that is $4,200. Now, because they lived a very comfortable life, the court determines that Patricia's reasonable need is $8,000. Minus her income of $3,000, the most Robert would pay is $5,000. But remember, the judge picks the lowest number. So in this case, Patricia would likely get $4,200 a month for up to 11 years. Ultimately, every scenario starts with need and ability. Then the judge uses real facts to fine-tune the number so the plan works in real life, not just on paper. Understanding how alimony can affect your situation after a divorce is a big part of understanding if you're ready to move forward with one. And there's a whole lot more. And that's why we created the Divorce Readiness Quiz. It's free, it's private, and it only takes a few minutes. It will walk you through the major considerations you need to understand before going into a divorce and let you know if you're likely ready or have some things you need to work on. I've put the link in the description. But if you're in South Florida and there's a safety concern, a fast-moving financial change, or a situation that is making a divorce urgent, don't wait. Call my Miami office to set up a free case evaluation. You'll speak with a real person, and they will help guide you in the next steps. Now, in my next video, we'll tackle how assets and debts are divided in Florida, what counts as marital versus non-marital, how houses, retirement, and businesses are handled, and the simple rules that prevent common mistakes. In the meantime, I'm Vanessa Vasquez de Lara with the Vasquez de Lara Law Group, where we make lives better in and out of family court. See you soon.